Hello everyone, I'm Leonard French, your favorite Hawaiian shirt-wearing copyright attorney. And tonight I thought I would talk to you about a recent trademark ruling by the Trademark Trial and Appeals Board, which this is a fairly interesting case. And I thought maybe everyone would have kind of a lighter Sunday with the Margaritaville Enterprises versus Rachel A. Bevis Trademark Trial and Appeal Board case. All right, I guess before I should start, I know we've had some technical difficulties on these things. Can everybody hear me? Is there any echo? And do I have any hidden pop-up windows in the back that are playing anything from when I started the stream? I don't think so. So, okay. So somebody on chat, let me know if there's a problem. So this just came out on March 16th. I didn't know anything about this. I just was reading through the weekend news and decided this might be a good topic for a video and maybe a good no echo, no extra noise. Great. So then we'll hear as the snow falls off my roof. If you hear any loud crashing, I don't think that's me getting swatted. I think that's the snow falling off my roof. So let's make this a little larger. So once again, this is Margaritaville Enterprises versus Rachel A. Bevis in the United States Patent and Trademark Office. These sorts of things are... So I've got this is cool now, right? These sorts of things are not adjudicated by a traditional court, and instead there is a Trademark Trials and Appeals Board that hears these things in Washington, D.C. They can go to a higher court on appeal if they have to. So this was just heard on February 28th. There was a hearing. It looks like the defendant, Rachel Bevis, Rachel? Let me turn off this clicky thing on my mouse. Rachel Bevis was represented by legal counsel, but then chose to represent herself. While acknowledging that the parties may appear pro se, the board advised applicant to secure the services of an attorney familiar with the board inter partes proceedings. So they advised her right away that she shouldn't really be doing this without an attorney. So let's keep this in mind and take everything with a grain of salt when we go through this. I think you'll see some things. Rachel Bevis has applied to register the trademark Marijuanaville in standard characters on the principal register for t-shirts, hats, sweatshirts, sweatpants, jackets, socks in International Class 25 and drive-through retail store services featuring coffee and related goods, retail apparel stores, and retail clothing stores in International Class 35. In case you're wondering what international classes are for search and archival purposes, you have to, well also, because it's a big part of trademark law, you have to categorize your trademark. And your trademark only applies within the categories that you have received a trademark for, that you're actually doing business in, and then those that you might reasonably expand in. And there's a whole lot of law there, so that's going to get more complicated than even I understand, because I am a copyright lawyer, not a trademark lawyer. Margaritaville Enterprises, known as the opposer, opposed the registration of applicant's mark on the ground of likelihood of confusion under Section 2D of the Trademark Act, based on opposer's previously used and registered Margaritaville marks. Opposer pleaded ownership of and submitted with its notices and opposition copies of multiple pleaded registrations obtained from the USPTO, including the following: registration number yada yada for Margaritaville in typed format and on the principal register for clothing, namely shirts, sweaters, sun visors, and caps, in International Class 25. And nightclub services, retail clothing, gift and souvenir store services, mail order services in the field of clothing, gifts, and souvenirs in International Class 42. So those are some pretty similar things, right? So if these overlap, then we've got a problem. And another registration for clothing, namely pants, sweatshirts, shorts, and dresses in International Class 25. In her amended operative answer to the notice of opposition, applicant denied, and remember the applicant is Rachel Bevis, is not Margaritaville. Applicant is Marijuanaville. Applicant denied the salient allegations, meaning that she denied the meaningful allegations. In her answer to the notice of opposition, filed approximately 3 months later, the then pro se applicant, representing herself, admitted several salient allegations, including the following: that Jimmy Buffett is an internationally famed musician, that Margaritaville is the successor in interest to trademarks filed and registered by Mr. Buffett, that Margaritaville provides goods and services associated with Jimmy Buffett, that Margaritaville regularly commercializes Jimmy Buffett song titles, that Margaritaville coined the term based on his famous song Margaritaville, and that due to long-standing and widespread use of the trademark, the mark is associated strongly with Margaritaville and Jimmy Buffett, that the mark has been used on a wide variety of goods and services for many years. Pardon me while I take a drink. And as a result, the mark is commercially strong indicator, a commercially strong source indicator for Margaritaville's various goods and services. Now remember, trademarks are important because they not only are a corporation's branding, but they're also the consumer's safety of knowing the source of the goods. So that's what they mean when it's a strong source indicator. It means that when you see the Margaritaville brand, you know it's associated with Jimmy Buffett and his chain or the chain of restaurants and other products that he's authorized. By virtue of Margaritaville's continuous and exclusive and widespread use of the distinctive Margaritaville mark, Margaritaville is entitled to a broad scope of protection, and Marijuanaville and Margaritaville share the same first and last 6 letters and are similar in appearance. The remaining salient allegations were denied. The board denied opposers' fully briefed motion for summary judgment, and instead the parties stipulated to resolve the matter under the board's accelerated case resolution procedure, which seems to be some kind of like arbitration or mediation. You can look it up yourself if you want under this trademark trial and appeal board procedure manual. The parties are commended for pursuing this expeditious, cost-efficient alternative to trial. In lieu of separate assigned testimony and briefing periods, the parties agreed to treat the summary judgment motion evidence as part of the final record with the option of filing supplemental briefs in summary judgment format with additional evidentiary submissions attached thereto. So they did a different procedure for this, probably to save money. The record includes the pleadings and, pursuant to the trademark rules, the application file. Opposers submitted with its motion the following evidence: the declaration of a paralegal employed by one of the attorneys, and opposers submitted a declaration of Jimmy Buffett, a chief financial officer, a chief legal officer, a chief marketing officer, a marketing consultant, a lexicographer and linguistic consultant, a singer-songwriter, and Mary Martha Adkins. Applicant did not make any evidence of record. Now that's weird. That means that the applicant, the pro se applicant, didn't really present any evidence to the contrary. So to me that says maybe the board didn't have much of a choice but to grant this opposition if the evidence that they have shows anything at all. But it does. I mean, you're going to see that. That's pretty clear. But why? Why is the fun part? Standing. Standing is a threshold issue, must be proven, yada, yada, yada. We're going to skip this. There is no question that the parties have standing between the applicant filing the mark and Jimmy Buffett owning Margaritaville or having assigned Margaritaville. So we're going to skip to the trademark claim. We will now consider opposer's Section 2D claim, focusing on opposer's registered mark Margaritaville. for the goods and services identified in the registrations made of record, yada yada. In our view, these two registrations, coupled with their corresponding identified goods and services, are most likely to support a likelihood of confusion claim. If a poser could prevail on its Section 2D claim on those registrations, then consideration of the others is unnecessary or moot. Priority is not at issue in view of a poser's ownership. In other words, one trademark doesn't have priority over the other. The Margaritaville trademark is being applied for, or Margaritaville trademark was applied for in 1979, I believe, and the Marijuanaville is a brand new application. Likelihood of confusion is the standard of trademark. We base our determination under Section 2D on an analysis of all of the probative evidence of record bearing on the likelihood of confusion. The court cites to E.I. DuPont and is going to rely on some of the case law that was set forth in this seminal case. Not all of the DuPont factors are relevant to every case, and only factors of significance to the particular mark need to be considered. For example, the board can focus on dispositive factors such as similarity of marks and relatedness of goods. The fame of the prior mark can be critical. These factors and the other relevant DuPont factors are discussed below. Fame of the prior mark. We begin with the fame of a poser's Margaritaville mark. Fame of the prior mark, if it exists, plays a dominant role in balancing the likelihood of confusion factors. Fame for likelihood of confusion purposes and fame for dilution purposes are distinct concepts. Unlike dilution, fame for likelihood of confusion purposes does not require the opposer to show fame among every segment of the U.S. population. Rather, fame for likelihood of confusion purposes arises as long as a significant portion of the relevant consuming public recognizes the mark as a source indicator. Fame for likelihood of confusion purposes may be measured indirectly by the volume of sales and advertising expenditures of the goods sold under the mark, for example, and other factors such as the length of time and use of the mark, widespread critical assessments, notice by independent sources of the products identified by the marks, and the general reputation of the products and services. Jimmy Buffett, the original owner of Opposer's pleaded marks, explains the genesis of the Margaritaville brand for clothing and retail stores featuring clothing in his declaration. In 1977, Jimmy Buffett, released the song Margaritaville. The song Margaritaville appeared on an album. I have performed it in my concerts. It is a term I coined to describe a fictional location. I regularly refer to Margaritaville as a state of mind inspired by margaritas. I mean, that right there, that has got to be one of the coolest lines I've seen in a court case. I regularly refer to Margaritaville as a state of mind inspired by margaritas. The images I most commonly associate with Margaritaville are beaches, tropics, leisure activities, and islands and escapism. In 2016, my song Margaritaville was introduced into the Grammy Hall of Fame. Based on the success of my song and the loyalty of my fan base, in 1985 I opened a retail store named Margaritaville in Key West, Florida. In addition to selling Margaritaville branded souvenirs, and including clothing in Key West, Florida, this retail store mailed newsletters named The Coconut Telegraph to my fans to purchase Margaritaville branded souvenirs, including clothing by mail and phone. What the Trademark Trial and Appeals Board here is doing is going over all of the fame and the basis for the fame of the mark, in case you're just joining us. Thus, the record shows that Opposer, through its predecessor in interest, has continuously used the Margaritaville mark for over 30 years to identify clothing items and retail stores featuring clothing, and that the mark has its origins in a well-known song by Jimmy Buffett, symbolic of a state of mind. By 2013, I could use a macaw, Sarah. By 2013, Opposer and its licenses had expanded its Margaritaville branded retail stores to 14 locations in the United States. Opposer's revenues from the merchandise sold in its stores are of record but are designated confidential. Suffice to say, the figures are impressive. Although the stores sell a wide variety of goods, at least half of the revenues are derived from clothing and headwear sales. From 1985 to 2013, Opposer and its predecessors in interest published a magazine entitled The Coconut Telegraph to promote the sale of Margaritaville branded clothing. Operated an online retail store since 1999. And through its social media platforms, Margaritaville has 677,000 followers on Facebook, 12,600 followers on Twitter, and 58,000 followers on Instagram. In terms of direct evidence of consumer recognition, in 2010, Opposer commissioned a brand awareness survey showing that of 841 respondents, 73% were familiar with the Margaritaville brand. While the survey is 7 years old, it is entitled to some probative weight insofar as it was commissioned prior to the instant litigation and was used in the ordinary course of business. In addition, Opposer has presented strong evidence of unsolicited media recognition of the Margaritaville trademark in connection with the clothing reminiscent of the Margaritaville lifestyle embodied in the song and the retail stores for such items. From the New York Times, Mr. Buffett, patron saint of the untroubled, has long been known for his business acumen. In some ways, with his approach to concert merchandise and tour sponsorship in the 1980s, he created the model of musician as entrepreneur that managers for artists like Madonna and Dave Matthews have pursued more recently. In Billboard, one of the most successful business side ventures initiated by a recording artist is thriving in the 48 contiguous states. That's where Jimmy Buffett lives when he's not slumming in his other pads. And Key West is where Buffett's Margaritaville store has been doing business in Buffett memorabilia and trivia. From Forbes, business savvy sure runs in the family. Warren Buffett's distant relative, writer and singer-songwriter, Caribbean rock songs, Jimmy Buffett has found almost as many ways to capitalize on his particular talent as Uncle Warren has. In Playboy, in the years since, Buffett's many albums have created their own sort of legendary geography, an elusive mythical place where the capital is Margaritaville, etc., etc. The Margaritaville trademark has also been the subject of numerous non-fiction books as an example of successful marketing of lifestyle brands. And then it goes on to cite Thank You for Firing Me, Brand Like a Rock Star, Create Breakthrough Products, Music Marketing for the DIY Musician. It also appears as in works of nonfiction as representing a state of mind that says, kick back on the front porch, chill out, have a beer, gaze mindlessly at the tropical surroundings. Anything that is a problem will have to wait until tomorrow because right now I'm enjoying my own little paradise. As illustrated below, the trademark Margaritaville is closely associated with a particular brand of clothing, style of clothing. He pretended to check the merchandise in Margaritaville's store. Instead, he eyed the passing crowd, examining the... Excuse me, I'm having some trouble speaking right now. Instead, he eyed the passing crowd, examining the people for familiar faces. Nothing. Don't you just love Jimmy Buffett? Kyle looked down at the cute brunette at his elbow. The mogul of margaritas is my kind of guy. Remember, Margaritaville is just a state of mind, not a place. Actress. They're filming a movie. Here in the casino. Vampires in Vegas. Really? That's exciting, the one wearing a Margaritaville t-shirt said. He didn't seem to. No like when he saw Charlene. Danny pulled into the drive beside the building, the goat man, in jeans and a faded Margaritaville t-shirt, with a broad-rimmed straw hat on his gray hair, was sitting outside the clinic on a bench. From Trick My Truck, but don't mess with my heart. You seriously need Stacy and Clinton to clean out your closet? Sarah says, why holding up my prized Jimmy Buffett Margaritaville t-shirt and tosses it to me. Do you actually wear this stuff? Hey, I'm a parrot head and proud of it, I tell her, referring to what a huge Jimmy Buffett fans are called, me being one of them. Fine, he said. He tucked in his Margaritaville shirt, felt the back of his shorts for his wallet, and awaited his orders from the Sarge, but they never came. Actually, I think I was reading that wrong, though the titles were above. So that was The Telltale Turtle. was the one that I liked above. These excerpts show that Opposer's Margaritaville marks have been the subject of widespread media and popular culture. Opposer has established that its pleaded Margaritaville mark is, for purposes of likelihood of confusion analysis, famous for clothing, namely shirts, sweatshirts, sun visors and caps, retail clothing, gift and souvenir stores. The goods and trade channels is the next section. The next step in our analysis is a comparison of the goods identified in applicant's application vis-a-vis the goods identified in Opposer's pleaded registrations. At the outset, we note that the involved applications and Opposer's pleaded registrations include goods and services that are identical, at least in part. Two applications both include sweatshirts, both include retail clothing stores. Given that the goods and services are identical in part, in each of these consolidated proceedings, this DuPont factor weighs in favor of finding a likelihood of confusion. Because the goods and services are legally identical in part, and neither Opposer's registrations nor the involved applications contain any limitations on the channels of trade and classes of purchasers, we must presume that the channels of trade and classes of purchasers are the same for these identical goods and services. For this reason, applicant's argument that she intends to market and offer her goods and services solely in locations that support the marijuana industry is unpersuasive. As such, the DuPont factor regarding similarity or dissimilarity of the established, likely to continue trade channels also favors a finding of likelihood of confusion. Another factor is the conditions of sale, another of the DuPont factors. Next, we consider the conditions under which the goods and services are likely to be purchased, whether on impulse or after careful consideration, as well as the degree, if any, of sophistication of the consumers. Purchaser sophistication or degree of care may tend to minimize likelihood of confusion. Conversely, impulse purchases of inexpensive items tend to have the opposite effect. If you're just joining us, we're talking about trademarks and the likelihood of confusion between Jimmy Buffett's Margaritaville and this private person, individual who registered Marijuanaville. And so far we've gone over that they want to sell basically the same things. They want to sell merchandise, and they want to sell items in retail stores and restaurants and things like that. And the court has said that there are several factors that we go over called the DuPont factors for establishing whether one trademark is confusing with another trademark. And so we're going over, I think this is the third condition, the conditions of sale. Applicant contends that it intends to direct its goods and services to consumers connected with the cannabis industry, and therefore confusion as to the source is unlikely to occur. But the identifications in the applications of Opposer's registrations, so Margaritaville, do not include any limitations regarding marketing. Nor do the applications of the Marijuanaville trademark contain any limitations due to marketing. When you register a mark, you can specify that it only applies to certain things or only certain words of the mark you're claiming ownership to, and this is unlimited, basically. In addition, they both include retail clothing stores and apparel offered at no specific price point. We cannot assume, as applicant, Marijuanaville, urges, that these goods and services are rendered to different classes of buyers in different marketing contexts and at different prices. Rather, we must presume that the goods and services are marketed to all ordinary consumers of clothing in the usual marketing channels. Ordinary consumers of apparel are likely to exercise only ordinary care, and given the lack of price restrictions in the identifications, may buy inexpensive clothing items on impulse. Accordingly, this factor also favors a likelihood of confusion. The marks themselves is another factor, keeping in mind that where the goods and services are identical, the degree of similarity between the marks necessary to support a determination that confusion is likely declines. We now consider the first DuPont likelihood of confusion factor, which involves an analysis of the similarity or dissimilarity of the marks in their entireties as to appearance, sound, connotation, and commercial impression. The proper test is not a side-by-side comparison of the marks, but instead whether the marks are sufficiently similar in terms of their commercial impression, such that persons who encounter the marks would be likely to assume a connection between the parties. So this is where they're going to try and understand what the consumer what their impression may be when they see the marks, and is there going to be some confusion. The focus is on the recollection of the average purchaser, who normally retains a general rather than a specific impression of trademarks. Our analysis cannot be predicated on a dissection of the involved marks. Rather, we are obliged to consider the marks in their entireties. It is axiomatic that a mark should not be dissected and considered piecemeal. Rather, it must be considered as a whole in determining the likelihood of confusion. Nevertheless, there is nothing improper in stating that, for rational reasons, more or less weight has been given to a particular feature of a mark, provided the ultimate conclusion rests on a consideration of the marks in their entireties. Excuse me. Applicant argues that the marks in question, applicant is Marijuanaville, applicant argues that the marks in question, Margaritaville and Marijuanaville, are completely different. You buy that? I don't buy that. As the prefix margarita denotes a mixed cocktail, whereas marijuana constitutes a plant. I see this a lot. Just because you can make an argument doesn't make it a good one. This is like the cargo cult science of critical thinking. Wow, I see this an awful lot. Let me just keep going, or I'm going to start ranting. Opposer, however, argues that the marks are similar in sound, appearance, connotation, and commercial impression. In support thereof, opposer has submitted the declaration of David K. Barnhart, an expert lexicographer and linguistic consultant. He was tasked with evaluating the linguistic status of the term Margaritaville and Marijuanaville as brand names for retail stores and apparel. In this regard, he consulted a broad cross-section of reference books, including dictionaries, thesauruses, encyclopedias, word counts, and handbooks of usage, and surveyed examples of usage from independently collected evidence of the use of the term Margaritaville and Marijuanaville. Ultimately, he offered the opinion that due to the shared linguistic properties of the two terms, when used in the contexts enumerated above, these two terms are similar and may result in consumer confusion. The issue of likelihood of confusion is the ultimate conclusion of law to be decided by the board. Further, the board has consistently held that although opinion testimony on the question of likelihood of confusion is admissible, it is entitled to little or no weight. So the board is saying that just because he's concluded that doesn't mean that they're going to automatically find in favor of that conclusion. For this reason, we cannot, as opposer urges, rely on his opinion testimony, the lexicographer's opinion testimony. The board also generally does not rely on linguistic experts to explain how a mark is pronounced. We can, however, rely on the evidentiary materials made of record to his declaration in reaching our own determination. Turning now to our comparison of the marks Margaritaville and Marijuanaville in terms of sound and appearance, both marks are similar insofar as they are single-term, 14-letter marks comprised of 5 syllables, each commencing with the same letter string mar and ending with the suffix ville. As to their connotation and commercial impression, the record shows a public association between the two terms as representing a similar state of mind induced by either a cocktail or marijuana. According to the record, the suffix ville is a slang term frequently combined with other words to denote a state of being. And the court cites to the World Book Dictionary, ville combining form, U.S. slang. In a state of being in or form. He's Despairsville. See, he's fed up with humanity. I just finished a book, and all I can say is it is like War and Peaceville. Margarita and marijuana are defined as follows. The term margarita, designated as a cocktail, is a well-established, being attested in print from at least as early as 1950. The term marijuana, designating a plant with addictive properties, is well-established, being attested in print at least as early as 1918. Thus, combining margarita and marijuana with ville results in coined marks connotating a state of being associated with either a cocktail or marijuana. A poser also made of record the following evidence showing popular culture and media usage of the term Marijuanaville as an allusion to Margaritaville. Quote, in 1998, Orlando Sentinel columnist George Diaz wrote, "Plug in the Jimmy Buffett CD, everybody sing along to that catchy tune, Wasted Away Again in Marijuanaville, in honor of pinhead Chris Webber, the erstwhile whiz kid who became Sacramento's headache in the off-season, was detained for possession of marijuana in Puerto Rico earlier this week." In 1998, Scott McCabe of The Examiner wrote in his Stupid Crimes column, "Wasted Away Again in Marijuanaville, a Florida Keys teen was arrested after deputies say he left his MySpace page called up on a computer at home that had been burglarized." Oh, that was smart. Deputies found no one inside, but they did find an empty soda and snack containers, some marijuana on a coffee table. In 2015, Five Seasons South Florida should decriminalize street pot. Columnist Daniel Vasquez wrote, "Think Marijuanaville. Tourists would prefer getting high in the sun and surf. Hunger-inducing weed will drive people to local clubs, bars, and restaurants. Along with Margaritaville in Florida, we could have Marijuanaville." In 2014, in a blog post titled "Perfect Names for the 6 New California States," one of them was Marijuanaville, the honorable mention. Like Margaritaville, but with more Buffets and less Buffett. More buffets and less Buffets. Singer-songwriter-comedian Mark Eddy has co-written and performs a tribute song called Marijuanaville. YouTube videos featuring the song have over 2 million views. And then the TTAB, then the TTAB puts up. I think this is Twitter. This is either Twitter or, yeah, this is Twitter. The connection between Margaritaville and Marijuanaville is also reflected on social media platform Twitter, showing a connection between the two terms among members of the general public. Later today, I'm heading down to Margaritaville. Is there also a Marijuanaville? 2 places I want to visit, Margaritaville and Marijuanaville. It's always 5 o'clock in Margaritaville. Is it always 4:20 in Marijuanaville? Some of my favorite places include Margaritaville and Marijuanaville. Thus, the overall connection and commercial impression of the marks is highly similar, a chemically induced mental paradise. The public is likely to perceive applicant's mark as an extension of a poser's lifestyle brand. Based on this evidence, we find that a poser's mark Margaritaville and applicant's mark Marijuanaville are similar in connotation and commercial impression. In sum, this first DuPont factor regarding the sound, appearance, connotation, and commercial impression of the involved marks taken in their entireties weighs in favor of finding a likelihood of confusion as well. The number and nature of similar marks in use on similar goods. We now consider the number and nature of the marks used on similar goods, the 6th DuPont factor. I'm assuming this has something to do with if it's more of a generic mark and not such a exclusive mark. In other words, so you may have there are a few trademarked terms that have actually lost their trademark over the years because they got used a lot, and then the companies never actually policed the marks and made people stop using them. I think Kleenex was one of them to refer to a tissue. I don't know if Xerox lost theirs to refer to copying. But some of those get very close, if not cross the line, into being lost because of dilution. I think this might have something to do with that. We now consider, applicant essentially contends that a poser cannot monopolize the commonly shared suffix ville, derived from the French word for town. Applicant, however, has submitted no evidence regarding either third-party use or registration of opposer's mark Margaritaville for the same or similar goods or services. See Palm Bay, another case. The purpose of defendant introducing third-party usage is to show that customers have become so conditioned by a plethora of such similar marks that customers have been educated to distinguish between them. So, since our applicant, the recipient of the applicant is Marijuanaville, since Marijuanaville did not submit any evidence, the Trademark Trials and Appeals Board doesn't have any evidence to go on showing that there are other products out there using a Margaritaville-like mark and getting away with it. As Opposer correctly notes, its mark is a coined term, arbitrary in relation to the goods and services, making it inherently strong. Thank you for the $2, Nick G. In determining the strength of the mark, we consider both its inherent strength based on the nature of the mark itself and its commercial strength based on the marketplace recognition value of the mark. Accordingly, this DuPont factor favors a finding of likelihood and confusion. We turn to the 7th DuPont factor, actual confusion and contemporaneous use, and the related 8th factor, extent of the opportunity for actual confusion, as argued by the opposer. As opposer correctly observes, the current filing basis for both of the involved applicants is intent to use, and we have no evidence that applicant has used its applied mark for or in commerce. Actual confusion cannot yet occur, and evidence of actual confusion cannot yet exist. These DuPont factors are neutral. The 9th DuPont factor, the variety of the goods. Opposer argues that both parties agree that opposer sells a wide variety of goods in multiple retail channels. However, because our finding of fame is limited to clothing and retail clothing stores, we deem this factor neutral in our DuPont analysis. What? Okay. I think they're just limiting it to... Oh, that's right. They said before they're only focusing on the goods or clothing and retail clothing stores because those two seem strong enough. And if the marks were found to be in conflict on those two, then they didn't have to do the rest of the analysis. So I'm guessing they didn't do the rest of the analysis. Market interface. Opposer also discusses the 10th DuPont factor, the market interface between applicant and the owner of a prior mark. This DuPont factor consists of a mere consent to register or use, agreement provisions designated to preclude confusion, limitations on continued use of the mark by each party, assignment of the mark, application, registration, goodwill of the related businesses, and or time or legally bound reasons called latches or estoppel attributable to the owner of a prior mark that indicate a lack of confusion. Latches or estoppel would be like if the owner of the prior mark stopped using it for a while or didn't enforce things for a while, and you came in and did your thing while they were doing that, and you think that you should be able to continue. According to the record, there is no market interface between applicant and opposer. In other words, opposer has not consented to applicant's use. The 10th DuPont factor, therefore, favors a finding of likelihood of confusion. The next DuPont factor raised by opposer is the extent to which applicant has a right to exclude others' use of its mark on its goods. There is no evidence that Bevis, the applicant for Marijuanaville, has any right to exclude others from using Marijuanaville except for any rights based on the applications, which are opposed in this proceeding. For this reason, the 11th DuPont factor favors a likelihood of confusion. So this is talking about if you've established any non-USPTO trademark rights, which do exist. And if you started selling something in your state locally under a name or something, you'd have some basic trademark rights under your state's law, or the laws of your country, most likely. If you don't know what those rights are, you definitely want to speak to an attorney or do some internet searches, because this video is not meant to be any individualized legal advice. Extent of potential confusion. Last, we consider the extent of potential confusion, whether de minimis or substantial. De minimis is literally minimal. Why we can't say, new good words that whatever. With regard to this factor, applicant argues that there is no realistic potential for confusion. Opposer points out that the clothing and retail store goods and services involved are directly competitive. Since these are the types of goods and services that would be marketed to and purchased by significant numbers of purchasers, the potential for confusion there cannot be deemed de minimis. Accordingly, this DuPont factor favors opposer. Balancing the DuPont factors, I don't know if you've been counting, but the vast majority of the DuPont factors have been in favor of opposer, and I think there were 2 or 3 that were just not applicable. So let's see where this goes. The record shows that opposer's mark Margaritaville is famous in connection with clothing and retail stores featuring clothing and is inherently strong. As such, it is entitled to a wide scope of protection. Famous marks are accorded more protection precisely because they are more likely to be remembered and associated in the public mind than a weaker mark. The goods and services involved are identical in part and are therefore presumed to travel through the same trade channels and be purchased by the same classes of consumers, ordinary consumers. Ordinary consumers of apparel are likely to exercise only ordinary care in determining the source of their goods and may buy inexpensive clothing items on impulse. When considered in their entireties, the marks Margaritaville and Marijuanaville are similar in appearance, sound, meaning, and commercial impression. In a correct assessment of the DuPont factors, the fame of opposer's Margaritaville mark magnifies these similarities. A potential consumer who is aware of an opposer's famous mark is even more likely to be attuned to its similarity to applicant's mark upon encountering the latter. The remaining DuPont factors discussed either favor a finding of likelihood of confusion or are neutral. Accordingly, we find that opposer has proved its Section 2D claim by preponderance of the evidence in both proceedings. The opposition is sustained. So I think that's it. There's an appendix with some things and a list of declarations and all that. So sorry, guys. Without the permission of Jimmy Buffett and Margaritaville, it sounds like we're not getting any Marijuanaville. In fact, anything, I bet you, thank you, Gizensha Fox. Let me know if I've pronounced that wrong. It sounds like, for the $5 donation. Thank you, Gizensha, for the $5 donation. Is that francs? No, that's British pounds? Geez, I don't even know my world currency off the top of my head. So I guess the best option or best opportunity we've got to get a Marijuanaville is going to be only if Jimmy Buffett partners with somebody and or gives some kind of permission. I'm going to assume that means either doing it directly through the organization that they've got now or licensing it to someone who probably pays them a very large amount of money or a very nice cut of the profits in order to do something like that. So, I mean, I'm not terribly disappointed that we don't get a Marijuanaville restaurant, but I do think it was a fun meme. I don't really see how this is a good thing for everyone, but it does create a likelihood of confusion, and when there's a likelihood of confusion, consumers could be fooled, and when consumers are fooled, they could buy something they don't want or didn't mean to buy, and I guess that's bad enough. So let me pull up the chat here, which you see scrolling on your screen. I'll leave this up, but I'm going to make it smaller real quick. There we go. So why is everyone referencing DuPont? I am not an expert in trademark law, at least not all of its case law, but DuPont was a famous trademark case that set forth 9 or 10 factors that should be considered when establishing whether a trademark is likely to be confused with another trademark. ISK? Yes, it could be ISK. Thank you, Sarah. I forgot about ISK. Oh, it's euros? That shows up in euros? Cool. How about Devil's Cabbageville? You might have a much more success doing something that wasn't so similar to Margaritaville. So if you tried to open Printerville store, yeah, you could probably open Printerville store. I don't think anyone's going to confuse Printerville with Margaritaville. But if you opened up, let's see, what's similar to a margarita? Martinisville. I don't know that you could open up Martiniville. That might be too similar, and people might think, and the T-Tab might agree, that Martiniville is too similar to Margaritaville. You could open up any kind of ville if it's not overlapping Margaritaville's international class filings. So in other words, T-shirts and merchandise and retail stores for said merchandise and all that. If you were instead opening up Printerville, that doesn't seem to be a problem until you maybe start creating Printerville T-shirts and Printerville restaurants, and then maybe Printerville might be a little closer to a trademark problem. I still think that one's a lot more clear. I think the court or the board was made a very good point that Margaritaville was not just a word, it was a state of mind, and so anything that generated that state of mind in the context of using Margaritaville or Marijuanaville or a ville or restaurants and all that, that was close to being a violation, and then when you add in all this other stuff, it became a violation. Other questions? It's not a 2-hour live stream. Yay! Gentlemen's club called Stripperville. Ooh, that's a tough one. It's a club. Now, Margaritaville has the right to nightclubs, right? So it could. I definitely see a basis for opposition there. Whether or not that actually is I don't know. Yeah, this is more along the lines of trying to trademark React from last year from the Fine Brothers. If we we can turn it into a 2-hour live stream. So the Fine Brothers were trying to trademark the word React for reaction videos, but that didn't work because React is a descriptive word, and it was going to make it difficult for other people to use and make reaction videos. And there was lots of prior examples of market uses for that. So that was very clear. Here, this just seems to be an individual person who was trying to capitalize off of the Margaritaville brand and state of mind and all that. And it makes sense. Yeah, certainly you could. There is a missed opportunity in not having a Marijuanaville, whatever, retail, restaurant, whatever chain. Colorado, Amsterdam, wherever, excuse me, there should be a Marijuanaville. It'd be fun. But for some reason, going to bed soonville bites back. Thank you for the $2. But that's under the control of the people who own the trademark that has already been established and is already in use. Please explain internal citation deleted. That was from, or omitted, that was from the expert's testimony, and it looks like he referred to his own work with a citation. And so they're just saying that they removed his citation for their purposes. As you see, these documents have a tremendous number of citations in them, and even though this was 37 pages long, it was only 40 minutes to get through. Thank you for the $5.39, really appreciate it. That this was really not 37 pages of material to read. It was included all those citations and footnotes and examples and things. Livestream doesn't end until he shows us the dogs. Yeah, that's coming. Let's see, who else has got a question? Do lawyers get incentives to take pro bono cases? Not in my state, no. We are encouraged to, and in some states you are required to perform a minimum number of pro bono hours and to file a statement that you've completed those. And lawyers are actually it's frowned upon for a lawyer to be dishonest with his own licensing organization, so you're usually filing those things under threat of your own license if you're lying. So that's not what I call an incentive, no. And so what I think a lawyer like me is going to do, because I've kind of got a strong public service streak and a lot of student loans, is I might focus on something like a pro bono or low-cost legal services firm, or maybe turn this channel into some kind of copyright Judge Judy style copyright court or something like that, or just have it like do a series of episodes like that. And by the time I put all this effort into all of this, it's a full-time job, and so maybe I could be incentivized through that. But no, I don't think there's too many programs that are actually trying to encourage and incentivize lawyers to take on these kinds or any kind of pro bono case. Cocaineville might not be able to be registered because it is for an illegal substance. Marijuanaville, they might have gone there, but that wasn't the basis in this case. I don't know about Cocainesville. There are some strange rules about what can't be trademarked. $5 to show the dogs. Okay. Emil, thank you. I appreciate the 20 DKK contribution. I don't know what that is, but I really appreciate it. I really appreciate it. That's the worldwide nature of this is amazing to me, that there are people all over the world that want to watch this stuff. Thank you, gorgeous Roddy Chrome. I'd make a great mediator, aka Judge Judy. And thank you for the $2, Sven Hook. Will you make a video on patents and the patent scam from X-Plane, Leopold? Yes, I do plan on making that video. It's on the list. Danish Kroner. Danish, wow, that's really cool. Thank you so much. I really appreciate that. Can I trademark my impeccable smile? No, but you do have the right to sell your own brand. You do have the right to make use of your own likeness, and nobody else can take that from you without paying you for it, supposedly. All right, let's see. Who else has some questions, and then we'll get to the dogs. Are you ever going to do a story on when Paramount sued the U.S. Navy over the name Enterprise? I did not know that happened. What? No. I gotta do a quick Google search here and see what this is. This is too interesting. My impulsivity. Paramount Pictures tried to sue the U.S. Navy over the name USS Enterprise. A fan was selling patches for the Navy ship Enterprise. A representative from Paramount walked up, demanded the unlicensed patches be removed. The fan explained that these were patches from the ship. So this person from the Navy they contacted was agreeable. He knew he was in the right, so he decided to have some fun. Let's take this to court. It'll take maybe 5 to 10 years. You won't be able to use the USS Enterprise name. Paramount backed down. All right, I'll have to look into the veracity of that story. That sounds like a fun one. What else you got for me? What if two people look eerily similar? Then, well, what would happen is one person would make something using their likeness, and the other person might say, "Hey, that's my likeness," and then they'd eventually figure out that the two of them look alike. I don't know about Taylor Swift suing, but she could definitely sue someone for using her image. Either copyright infringement by selling an image of something, or like, let's say I painted a Taylor Swift poster and then I want to sell that as fan art. Well, you can't, not without permission. So if anybody wants to create stuff like that and has, well, created it all, but really wants to try and sell it and make it a big deal and make it publicly available, you have to have permission for that. It's in a way, it's a bit sad, but you either have to have permission or you have to know fair use law and make sure that what you've created is a transformative fair use, or else, sorry, you are open to a copyright claim. Where are we? Oh, there's so many questions now. Blood Splat, thank you for the $5 Canadian. If someone does a work of their own likeness, okay, we just did that. If the clients countersue Matt Haas, will the legal fees be so expensive that it's not worth it? Yes, if the clients really have encountered $100,000+ in legal fees and they hands down win the case, they can apply without countersuing for that money back, and Matt Haas would owe it to them. Many times parties settle this part of the lawsuit, but you know, we haven't really settled this one yet, so who knows what's going on there. Would you look into if X Kinda Funny's Colin Moriarty has a case against IB Times for calling him a racist in the headline for a sexist tweet? That's a tough one. What is defamation or libel or slander? Sometimes an opinion is not, or oftentimes an opinion is not libel or slander. I could say, or someone could say, he's a racist. That is less of a fact and more of an opinion. Maybe something less on the line would be clearer. I call this the game of hyperbole. Instead of racist or sexist, what if they said he was a rapist? That would be actionable if he was not a rapist. If they said he was a thief, that would be actionable if he wasn't a thief. If they said he's a racist, yeah. Oh, that's a really tough one. You could probably make an argument based on something anybody said that they might be a racist. So that's a hard one. Can you trademark your own name, even if it's similar to a famous person's name? Yes. See Nissan.com. NISSIN.com. In fact, it might... now I don't have the live stream set up for that, and who knows what'll come up when I open up the browser. So let's not do that. What do I think of Polish zloty? Hey, I'm half Polish, Zuberuber. Thank you so much. I really appreciate that. 10 Polish zloty. Where was it? I wanted to talk about the thing with Oh, I must have gone too far. The Robin Williams Aladdin likeness thing. They said they wouldn't use his likeness for merchandising, and then they did. So I read about that a couple weeks ago. I forget exactly what the dispute was beyond that, but I think they resolved it by donating some money or something like that. Or somebody in the comments or in the chat remind me. I don't know about the Blurred Lines Marvin Gaye lawsuit. What was that one? Watching a stream of a movie that's not licensed by the site, you technically break copyright. And there was an example of a company or a website called popcorntime.io that was embedding a BitTorrent client into JavaScript or something like that, and was basically doing a Netflix-style BitTorrent streaming service. And yes, those people were guilty of copyright infringement and were liable for copyright infringement if they got pursued. If you choose to represent yourself in a case like this, are there any legal fees? No. The fees would only be any costs for filing or traveling to the hearing. Maybe Rachel Bevis was not in Washington, D.C. and had to travel, so she'd be responsible for those costs. What if you paint a caricature well, then it's still going to be on a standard of substantial similarity. If your original work still copies someone's likeness, that's not copyright infringement, but I believe that's use of their likeness or something like that. 20 Swedish kroner, thank you, Chash Modai. Really appreciate it. You're amazing. There was an interesting case in Minnesota of a lawsuit over a bar here called Joe DiMaggio's, yet it turned out the owner's name, how is it with the same names? Yeah. You can have a Joe DiMaggio's bar, which is owned by a Joe DiMaggio, which is not the famous Joe DiMaggio. Is he going to be able to expand that bar to a national chain and make all these shirts with Joe DiMaggio on it? And then, no, he's not going to be allowed to do that. But definitely can have your business be named after you. That's fine. No one, if there's another Leonard French in the world, and there was, rest in peace, Australian stained glass artist Leonard French, who passed away a few weeks ago. He and I could not have a disagreement because he'd be allowed to do his business, I'd be allowed to do mine. Thank you for the 50 Swedish kroner. Wow, that's amazing. I just saw that come through as well. Can Obama sue Trump for libel over wiretapping claims, assuming they're proven false? Yes, though that could be a libel claim, right? Because it's a false statement, and it is definitely something that could damage someone. Now the question is, does Obama have provable damages against Trump? Maybe not. I don't think anyone. If the country collectively stopped buying Obama's book, and that could be connected directly to the wiretapping statement, that would be actionable damages under defamation, I think, but not without some provable damages. And I don't think that it would work out well for anyone. I think Obama would actually look worse by trying to sue Trump over more or less a trivial thing. I would call that lowering oneself to someone else's level. And I'm not getting into politics, but if it's true that someone lied about a wiretapping claim, yeah, that's not exactly the nicest thing to do to somebody. How does the party's likeness apply with impersonators? Usually they're impersonating a public figure, and that's allowed. It's usually like a satire or acting or live performance or something like that. We're talking about using their likeness in the sense of, like, if you dressed up as George Bush and went to sell cars and said, hey, I'm former President George Bush, buy this car, that you're not allowed to do. However, you can get on stage and perform a George Bush impersonation or comedy routine. That's perfectly allowed. How is Twitch not infringing on fair use? YouTube and Twitch are two separate organizations. I think Amazon owns Twitch, and they just may have different policies as to how they interpret their duties under the safe harbor provisions of the Digital Millennium Copyright Act. The reason why Twitch and YouTube take things down upon receiving notice is not only because the law tells them they have to, but because if they don't, they are liable for the infringement themselves. And while they are following the law as best they know how, they are not liable and are basically immune from copyright prosecution. So that's why they take stuff down aggressively, because they would much rather piss off a small YouTube creator than a big YouTube creator or outside copyright holder. How would DMCA cases play out if the people were from two different countries? Can you sue someone abroad? Well, the DMCA is an American law, and so you'd have to sue under whichever law applied to the difference in jurisdiction. And there's a huge amount of law about how jurisdiction applies. But the very basics are that you need to sue somebody where they've made themselves available to be sued in a legal sense. YouTube is in the United States, so they can be sued in the United States. They're in California, they can be sued in California. They sell to Pennsylvania. Okay, maybe they can be sued in Pennsylvania for selling things to Pennsylvania. Um, they don't sell anything to Vermont. They're banned in Vermont. Probably can't sue from Vermont because they don't have any business in Vermont. So when you have two separate countries, let's say Canada and Japan, which was a recent one, you would have to figure out whether Japanese law applied, American law applied, or Canadian law applied, and then sue in the appropriate court. It might be that a Canadian citizen has to sue a Japanese defendant in the United States because they're both on YouTube. That's not an impossibility. Could I just say that Kanye West is an utter nutjob? I support that statement. I support your right to say that statement. Now, whether he's a genius who is acting like an utter nutjob because it gets him views and attention, that, from what I understand, Kim and Kanye are actually fairly intelligent people when it comes to business and marketing. So that's only hearsay. I don't know for sure, but I wouldn't be surprised if they're more normal people in the background, and because they're less normal, kind of upfront. And I mean that word normal gently. All right, let's keep going, or this is going to become a 2-hour live stream. If you know the opposing party is insolvent, is there a reasonable argument to apply a lawyer fee to the opposing party? Does the lawyer best advise their clients to do so? Yeah, yeah. When you're deciding whether or not to sue somebody, yeah, you decide to sue based on, one, do you have an actual claim, and two, is it worth prosecuting it? Is it worth the damages that you're going to get? Are you going to actually get any money? And is it worth any public exposure that you're going to get? Sometimes suing someone will not get you much money and not make much of a point, and so it might not be worth it. Could clam shatter be trademarked? Yes. If nobody else is using clam shatter and you start using it in commerce, you can register it. If you intend to use it in commerce, you can pre-register it. Can you sue someone if they owe you money and don't give it back? Yes. And there is a time limit. It's called the statute of limitations or the law of limitations, and you have to look it up for your particular area, whatever county, in whatever state, in whatever country you're in, and that will tell you how long you have to sue and what the and then when you look up the law for contract, it could be a breach of contract, or there are some other legal. Sorry, I'm adjusting myself. There are some other legal claims that you could make. I don't know how to pronounce it, but I'll try it. Siarhe Pilat, thank you for answering my question. Papa bless. You're very welcome. Thank you for the 50 Swedish kroner, it looks like. All right. Can a dance move be copyrighted? Ah, that is a tough one. I don't think a dance move can be copyrighted. So, like the moonwalk. If Michael Jackson performs the moonwalk on stage and then somebody else performs it, that's a tough one. I don't know. My gut reaction is no, that a single performance move can't be copyrighted or trademarked, but I could also see an argument going in the opposite direction if it was that unique. But then no one could use that. I don't know, that's weird. That one I would have to think up. What if a trademark named Circle R... I don't know what that is. What if a trademark... you can't register a trademark on the state level. It's more like you establish trademark rights by using it, and then just by using it, you have some rights. You'd have to prove it. You'd still have to prove it. Graphite Gaming, yes. The mic, for whatever reason, I keep trying to sync it up, and YouTube always syncs my mic out just a tiny bit. So this time I think actually, can I adjust? I don't think I can adjust that while the stream's going. Next time I'll try and do that. Oh wait, here we can. I want to say I needed a 100 millisecond delay. Let's see if that helps. On the audio. The audio actually was ahead of the video by a little bit. There is still a version of Popcorn Time. Did Michael Jackson try and fail? Can we get a number count of your hats? Yes, I have many hats, probably several dozen. And as soon as I clean up my place and get some camera equipment that I can move around, I will probably show you my hat collection. Nico, while I'm reading through this. You want to be first? Okay, come here. Come here. You be first. You be first, Ilsa. Hello. Hello. Nico. Hup. Nope. Come on. People can't see you. People can't see you. Hi. Hi. Yes, this is Nico. This is my lover. This is my dog lover. He cuddles with me at night. Have you thought about hiring an editor? I've thought about hiring people to help me. What inspired me to study law? An overly developed sense of fairness and justice. Maybe I saw some injustices as a child and they stuck with me, and I decided that I wanted to make a difference in the world and just needed to pursue something that allowed me to make that kind of a difference. Oh, he is a lover. How accurate is My Cousin Vinny to actual courtroom proceedings? Great question. It is very accurate. So in the beginning of the movie, first when Vinny comes down and he talks to the kid and says, you know, there's no way this isn't going to trial. That's absolutely true. You're in you know, the deep South and you killed a good old boy. There's no way you're not going to trial. So that, you know, that's true when he screwed up the arraignment. The opening statement where he stood up and said, everything that guy just said is bullshit. I had that happen to me 2 weeks ago. I had some testimony of an expert witness in a child custody case, and after the expert witness testified in favor of my side, the opposing side, once again representing themselves, pro se, they got up and they said, you were coached really well. Everything that person just said was 100% false. And then sat down. And I just started to go, objection. And before I even got the first utterance of a syllable out, the judge said, sustained. Those statements are stricken from the record. And it was really funny. I really felt like I was in a My Cousin Vinny movie. The voir dire of expert witnesses is also correct. The movie is actually very accurate, and I really appreciate the time they put into making that accurate. Can I practice law in another country? Probably not. I can practice individually, like for one case here or there, if the court allows me in. In fact, that's I skipped that part in My Cousin Vinny. You also see the part where he goes into the judge's chambers and he has to read the big fat law book and understand their local rules and everything. You may remember from one of the H3H3 episodes that that there are local rules and judges' rules and all that, and that's what he had to know. And so the judge was evaluating whether or not he was allowed to even appear for the case. And then that plot device occurred through the whole movie, and at the end of the movie, you heard another judge called in for him and gave him a good word so that the judge in their case would let him appear. So if the judge decided you're not competent to appear, he could invalidate the whole trial, invalidate the acquittal of his clients, and have the case heard all over again with a new attorney that was going to cost them actual money instead of, a family favor. Have I ever had to defend someone I knew was guilty? Heck yeah. No, actually, quite the opposite. The cases where someone is guilty are actually fairly easy. You do the best you can to mitigate the damage, to help them through this difficult time, and have a fair trial. I don't think Nico wants to be on my lap anymore. But you just do the best you can to help them mitigate the damage and make sure they've got a fair trial or fair matter or whatever. It's easier to represent guilty clients than it is to represent innocent clients, because anything I do that screws up for an innocent client, then that person is going to be hurt, and they didn't do anything in the first place to really deserve this. The in-between ones are also kind of tough when you're not sure whether your client is guilty or innocent. But the point is that we have a professional responsibility, and we simply go through our rules and maintain our professionalism and represent the person as best that we know how. These dogs are on the same level as the Supreme Court. And yeah, I feel like I gotta go watch My Cousin Vinny now again, too. How accurate is Boston legal? No idea. Haven't really watched it. It's been a while since I watched TV law dramas. I tend to start yelling at the TV a lot. If I use a copyrighted song in a parody video, is it okay to use the copyrighted song to enhance the parody aspect? Actually, it's required. If you used a copyrighted song for parody, you've got to be using it to make commentary on the original work, or it's not parody. It's satire. And satire is not protected by copyright fair use. Only parody is. Will I have your child? We can talk. Has any of your clients ever said, I did it, I just need an out? Yeah, sure. I can't give specific examples or anything like that, but yes, many people say, hey, just help me through this as best you can. And that's exactly what we're supposed to do. Would I ever represent myself? I have very rarely represented myself, but I've also not been in that much trouble, knock on wood. If you were to ask a client if they were guilty, would their response be protected within the bounds of attorney-client privilege? Yes and no. This is a tough one. So I have two conflicting responsibilities. One, to represent my client competently, and two, to be honest and open with the court. I cannot lie to the court. So what skilled defense attorneys will do is they'll ask very careful questions. They'll get a new client and they'll say something like, I don't want you to tell me anything more than I'm about to ask. Were you here? Did you do this? What the yada yada yada? And they'll skip the parts that they don't want to know the answer to. And then they'll go to court and ask the questions that they need to ask and do their job, not knowing whether the answer to did you do it is yes or no. And that way they don't breach any responsibility if the defendant decides to lie. If I do know that someone is lying, I actually have an ethical responsibility to not continue to advocate for their lie, and instead I have to back off of that testimony and move on to something that's not a lie. Yes, one of the goals with helping someone who's either guilty criminally or guilty of something other than criminally, like a traffic citation or something, is just to give them the same break that everybody gets. Almost everybody gets some kind of break, as long as they're a more or less nice person, otherwise a law-abiding citizen, and otherwise trying to not trying to make a huge problem. They will usually give most people a break. So yeah, that's the goal, is to get the best break possible. Thank you from Francis, or to Francis Usher. Leonard, you make some of the most interesting videos on the internet. From the perspective of a legal layman, you are doing a great service. Cheers. Well, thank you, Francis. I really appreciate it. This has been a blessing for me, too, and I look forward to the mutual, symbiotic relationship that we all have together here. Did I see the Project Veritas video exposing the teachers' union lawyer? Ooh. Somebody, Sarah, make a note of that one. I want to look that one up later, please. Have I seen Jim Sterling's response video about the whole lawsuit? Which one? The James Romine lawsuit? I did, and that was a really good video, and it actually answered some of my questions, too. What is the difference between imitation and emulation? Wow, you guys are getting really deep with these. So imitation would be like making your own original, and emulation would, well, I guess I went straight to the technological definition of it, but I would think emulation would be a little more of an actual copy. Could a client answer after the fact and not have to worry about double jeopardy, or would they be open to perjury charges if you were still on retainer, or would it be an ethical black hole? No, this would be if the client was answering questions in court. Those things don't apply that way. They could be open to perjury charges if they lied, yes. If then I continued to lie, let's say that I know they're lying and I continue to ask them questions that support their lie, and the judge later finds out that they lied, then yes, I can get in trouble too. What I have to do is just simply move away. Does double jeopardy apply to copyright infringement lawsuits? Yes. If you have had your claims adjudicated, you cannot have those same claims refiled. Have I ever had a client that I didn't want to represent? Yes. It usually happens afterwards. It usually happens after we are already in the middle of things, and much like a bad relationship with a person, like a bad interpersonal relationship, maybe you find out that they had expectations that you were unable to anticipate, and maybe they become a very big burden or something like that. And you have to anticipate this as best you can in your agreements with your clients, and deal with them as best you can, as gently and politically as possible. Can I explain jury nullification? Yes, jury nullification is when someone is criminally charged and the jury refuses to find them guilty. If it's very controversial, because prosecutors and judges will not allow most attorneys, defense attorneys, to tell the jury that they have the right to nullify. So it can only happen in rare circumstances, when either they're allowed to be told, or when they know and decide that this circumstance does not warrant finding of guilty. You might see this in cases where police officers might have shot an unarmed person or something like that, and the jury just simply does not believe that the police officer should be prosecuted for that. There's probably some other good explanations, but I went straight there with it, didn't I? How do you feel about conflicts analysis and their place, analysts and their place in the legal field? I don't do enough of wide variety of business to need too much conflicts analysis. The vast majority of my clients are anonymous from each other, so very little conflicts analysis over here. When big firms represent various companies, and yes, they have to hire people to make sure that there aren't conflicts of interest. What's the hardest conflict that I've had? I represented a sovereign citizen once, and I wanted out of that case so quickly. We're going to do an episode on sovereign citizens, either a podcast or a either a podcast or a video, or a whole video series on sovereign citizens and the trouble they get themselves into. In fact, I was thinking of doing an episode of Len and Sarah become sovereign citizens, and what it takes to fall into this scam and start to believe some of these lies. How accurate is 12 Angry Men? I thought that was pretty good. I really liked 12 Angry Men. I remember it a little bit less. I saw it a while ago. No, I don't necessarily agree with a lot of IP law, particularly the file sharing cases that I deal with on a daily basis. There's a lot of money at stake, and there's not a whole lot of injury. Sure, a person may have committed an infringement, but we're talking about an infringement that becomes worth many thousands of dollars, whereas even walking into your local video store and walking out with a video does not constitute a theft of thousands of dollars. So it's a disparate. There's a disconnect between the offense and the punishment, and I don't think that that's appropriate. Who's a good boy? Who's a good boy? Huh? Ilsa, do you want to come back up since he doesn't want to? Okay. If someone is found innocent and right when they leave the courtroom they admit to doing everything, it's not necessarily safe for them to do so. There are a few ways around double jeopardy. I don't know them. I'm not a criminal defense lawyer. Yes, and Twitch and Sid Alpha just did a bit on the swatting of a Twitch streamer. Always a concern. We're going to play with the toy now. Hey, Ilsa, you want to come show your toy? Get your toy. Come on, get your toy. Go bring your toy. And she's just going to stare at me. Do you think the maximum statutory damages of $5,000, like in Canada, would do enough to make file sharing cases more fair and just? A little bit. Maximum statutory of $5,000 would probably be better. I don't know why it's $150,000 in the U.S. without some kind of clear limit on why $150,000 and when you go there. Did I take any special high school classes? No. There's no pre-law. There's no really one pre-law track. You decide what kind of law or what things you're interested in. You take classes in those. You do well in school, and if you've done well enough, you apply to law school after taking your LSATs and go from there. Usually your LSATs, your law school aptitude test scores, tell you what law schools you qualify for, and then from there it's just the competition of beating out the other people. I went to a law school that did not have terribly high admission requirements. It was right next to me, 86 miles away, but it was the closest law school that I could make it to, and so that's what I did. Was I went to not a top law school, but rather one I could actually get into and commute to. Can I give personal advice on cases I want to legally pursue? Well, yes and no. I do have to be careful of when I give personal advice to people online because they're not always in my jurisdiction in my state, and I don't always know what their law is in Canada or in California or something like that. So a lot of this is very general reporting and analysis and less individualized advice. Is there a case I feel bad about not winning? So far, no. So far, I haven't had any major losses where I anticipated winning and we lost. Definitely had cases where I settled them because I anticipated that we would lose, and the settlement was going to be cheaper for everyone. How do I feel about EU privacy law with regards to the right to be forgotten or deleted from the internet? That's an interesting one. I think there is some merit to that. I'm not used to that though. I wasn't raised like that, and I'm not used to thinking like that. To me, if you've done something, it should remain on your record forever, right? But then when we think about the criminal law, there are offenses that we don't want on our record after a period of non not non-infringement, but a period of no arrest or a period of no misconduct. So I get that after a period of no misconduct, maybe a person could apply to have their misconduct removed from the internet, much like they would a criminal charge. So I think it might be just a matter of that's their culture in the EU. I don't know. Prosecution defense, parasidious, would. I was on jury service in January, and my impression was that the prosecution/defense didn't have much clue what they were doing. How much time do you get to prepare? Depends on the case. I'm a private attorney. I get a lot of time to prepare. A defense attorney, a public defender, might get 6 cases that morning and might have 15 minutes or less to look over them. So sometimes that does happen. And then we can overlook germane and salient facts, and that might prove our client's innocence or go towards a lesser sentence or something. So that's often not considered the due process of law or substantial justice, and those people have a right to appeal sometimes because they didn't necessarily get a fair trial because they were advised so quickly without their public defender having a meaningful chance to review the record. Was the John Steele case a form of entrapment? No. If entrapment is from the government, it was definitely a form of coercion or extortion, where I think the words that would apply. Entrapment is when the government gets you to commit a criminal act that you wouldn't normally commit, but induces you because you think that there's some need or otherwise they've gone farther out of their way to convince you to do something that you wouldn't normally do. Harvard doesn't require LSATs. I don't know. Maybe they find that their applicants are so close together that they want to look at the merits. I don't know. Do you ever dress like Matlock and walk around like him? No, but I do dress in suits and go to court, and I tend to play it more like Columbo, and I wait for others to make mistakes. And it works an awfully large amount of time. Is it possible to bring up nullification during selection to avoid being on a jury? Oh, I never thought of that. I don't know why I never thought of that. That's a good one. I think that would work. No promises, no legal advice, and nobody sue me, but holy crap, I think that might work. You probably would get thrown right out. Have I ever been conscripted into public defense? Story time. Yes. One time I got conscripted into defending a person who was accused of drug possession. And the thing that was weird about it was that I had not applied to represent anyone. I was not a public defender, but I got a notice of representation, a notice of assignment of case in my personal mailbox at my house, which is not my registered mailbox and is not my registered office. So I already thought something was up, but I didn't. I was a brand new attorney and I had no idea, so I called up my mentor and he said, okay, well, whatever it is, just show up and do it. It's easy. It's a simple possession charge. So I went to the court, which was the traffic style court, the little court, the MDJ court, Magisterial District Justice, underneath the main courthouse, and I met with my client, and we discussed that I was going to apply for the judge to just charge him the fine and not give him any jail time for his simple possession charge. And we went over all of the details of why. And then another person walked in and said, hi, I think I'm your public defender. And I showed her a piece of paper that had my name on it and his name on it and said, no, I think this is my client. And she's like, oh, okay, I guess there's been a mistake. And she said, go ahead. And I talked to her for a moment. She was a real public defender. So I said to her, and this is what my plan was. Does that sound right? And she confirmed that was exactly what she would have done. So I went in and I talked to the judge and I said, hey, judge, this person, simple possession charge, has a family, yada, yada, yada. It would be great if we could just do fines and costs on this one. The officer agreed. The judge agreed. The judge starts looking through the paperwork and stops. And she looks at me. And she looks at the paper. And she looks at me. And she looks at the defendant. And she said, what's your name? And I said, Leonard French. And she hands a piece of paper to her clerk and says, figure out how this happened. And then said, all right, sir, have a good day. So I have no idea what happened, right? Well, I walk back out and introduce myself again to the public defender, who said, hey, how'd it go? I said, I don't know, it was great, we got what we wanted, but the judge did this weird thing. And she said, yeah, I thought that might happen. My name is Alexandra French, that was probably for me. So yes, I was accidentally conscripted into public service. That's my Yes, there we go, Sarah. Yes, we need to open up a t-shirt store and jury nullification. We'll gotta put something on the jury nullification on a t-shirt or something there that you can wear to jury duty. Or maybe a hat that says, I love jury nullification, that you wear to jury duty, right? That'd be great. Let me see if I can not miss all of the questions. Let's say that H3H3 used the siren sound from Kill Bill in their videos. And let's say that it's under copyright to enhance a parody video. Well, parody would mean that the sound they used was being used in a way to criticize Kill Bill. So that's parody. If they used it as satire, it would technically be copyright infringement, and Quentin Tarantino or whoever owns the rights to Kill Bill would have the right to sue or take down that video or whatever. Can you copyright a plot? Well, the only way that a plot is copyrightable is when it's specific enough that another plot comes along and is substantially similar to it. It has to be really substantially similar. It can't just be one of the normal, 36 epic arcs that are established in storytelling. I know this is a controversial point, but there was some Harvard study or something. I'm speaking out of my ass here, but there was some Harvard study or something that established that there were only so many plot elements or so many epic arcs that you can have as plots in stories. Like, boy meets girl, girl meets boy, and then, somebody's upset, they split up, they get back together, they they commit suicide, whatever. The plot from The Jets and the Sharks. Anyway, so the point is yes, you can have that can be copyright infringement. Hey, thanks for the $2 and the $5 for story time. And where the heck did this 50? What in tarnation? Slappy826, thank you so much for the $50 donation. That's amazing. What's the most interesting thing I learned in law school? There's a lot of interesting things, but one of the most interesting things was that lawyers can't lie, like I was talking about a little bit earlier. Yes, we can, but if we get caught, it has huge consequences, and in fact can undo cases and can undo our licenses, and it can even subject us to sanctions in the form of money or jail time that we have to pay if we've lied and it's caused damage. How often do companies pursue people making personal copies of media? You're allowed to make a personal copy of media, so that's definitely not copyright infringement. Could you make copies and redistribute them and get caught for that? Yes, you very well could. Damn it, it is almost a 2-hour live stream. Macheno. Mucheno. How did they screw that up with the thing, with the representation thing, the conscription into public service? I would have been furious. It was an educational experience for me. I wrote it off as just a mistake. They meant to send it to the new public defender, Alexandra French, and instead sent it to Leonard French. Whatever. I've had that happen before. It happened just a couple weeks ago where they sent something to a different attorney, somebody Francis, instead of French. It was just a typo. They typed in a number wrong on my license number, and it happened. The recent one that happened was not a problem. I identified it and corrected it. But if I got another public defender notice, yes, I would call the court and find out what's going on. Bites back. Have a good night. Thank you for watching the stream, joining the stream. I'm in my 30s, but never been called for jury duty. It's a numbers game. You're in a pool, and if they have found you, then you've been put on the list. Usually, it's by your voter registration or license, driver's license or something. So perhaps you aren't registered to vote in that area, or you don't have your driver's license in that area yet, or your address or something. Otherwise, it could just be a fluke. Maybe your name is similar, they got something wrong, or you just haven't been called yet. Is my title technically Esquire? Nope. Well, or is that a special kind of lawyer? Is my title technically Esquire, or is that a special kind of lawyer? No. It is not a special kind of lawyer. All licensed attorneys are called Esquires. Unlicensed law degree holders are called Juris Doctors, and are not... They're sometimes called lawyers, but they're not licensed attorneys. Usually, an unlicensed JD holder working in the field is not called a lawyer. Sometimes they're called professor, but only when they're teaching. But Esquire is reserved solely for licensed attorneys. But not trying to get political, but would getting Mexico to pay for a wall be extortion? I'd love to see how you get Mexico to pay for the wall. I don't think that economics work the way that that particular person thinks they do. Now, he owns many businesses, and perhaps he's doing the Kanye West, Kim Kardashian thing, and he's really smart behind the scenes, and this is all just a ploy to play to his base. I don't know. I do not feel like I have a terribly strong say in my government. I do not feel like my voice is worth one human person's voice in the government. So, that's a really tough one. William S. just got onto the stream. You're a little bit late. We already went through everything, but basically, Marijuanaville can't be registered as a trademark because Jimmy Buffett owns Margaritaville, and both represent a source of goods of a state of mind. The company is using the state of mind to sell clothing and merchandise and open restaurants and things, and because of that, can't register Marijuanaville. Keep the stream going all night. No. If you keep donating money, I'll keep the stream going all night. How about that? No, today is Sunday. I have work tomorrow morning. I have, real work tomorrow. No, this is real work. Don't get me wrong. This is real work. This is good work. But, I mean, I have, responsibilities to individual people tomorrow, and it would be bad if I wasn't on my game. Are prosecutors any different personality-wise than other attorneys? No, actually quite the opposite. I think it's attorneys that have weird personalities just in general. I haven't really met one attorney that's the same as any other. They're all extremely unique individuals who express their personality traits in their own ways. And I think it's just maybe a product of either the intelligence or the training, or I noticed personality changes in me after being exposed to so many adverse and hostile things just from practicing, seeing people treat each other badly, seeing companies treat people badly, seeing companies treat companies badly. I lost my, what's the word? My my virgin eyes. I lost my innocent and naive view on the world, and so I think that has a bit of an effect too. Sometimes that can be traumatic for people. Other times it can induce them to alcoholism or drug abuse. And attorneys and doctors and some other similar professions have a much higher rate of alcohol and drug abuse and suicide and mental health issues and dysfunctional families and dysfunctional relationships, et cetera, et cetera, et cetera. It's easy, Leonard. You take money from the money you give them. Okay, are we giving money to Mexico? I don't know. It could either be that we take away money we give them, or that we impose a tariff or something. But they can impose a tariff back, and international trade is not one of my areas of expertise. I personally kind of like the free trade that we have going on with Mexico and Canada, and it seems to be the China and Russia as well, because I order lots of electronic parts and batteries and things like that from all over the world, and I don't seem to be paying too much in the way of tariffs, unless I'm supposed to be, and these items are arriving in my mailbox untariffed, and they're supposed to be. I don't know. If the glove does fit, would you not acquit? Yeah, that was one of the strangest arguments I've seen, and I didn't expect it to work. So you're saying that I can go wear gloves that are a size too small and get off of a murder charge? I know, that's hyperbolic and oversimplified, but it didn't make a whole lot of sense, did it? And we've certainly seen enough evidence afterwards that he probably did commit the crime. Do I believe in any conspiracy theories? I would like to see more. I'm going to totally discredit myself. I would like to see more about 9/11. I mean JFK too, but I wasn't there for JFK. I was at least working and saw the effects of the Twin Towers falling, and they fell very weird way. It looks way too much like a demolition, a controlled demolition, but I'm not what I would call an advocate for, Bush did 9/11 or anything like that. I just think I'd like to ask some more questions if I had the opportunity, but that's about as far as I take that. It's just it's an interesting thing to wonder about sometime. "7-Eleven was a part-time job." Opinion on Martin Shkreli. I'm gonna file him away in the same plane as Kim Kardashian and Kanye West. Maybe it's an act, or maybe he's just that much of a jerk and doesn't care because it doesn't affect him in his circles of friends. Okay. I've also heard from people who said that maybe people who do those kinds of things don't have normal friend relationships like healthy people have, but then again, we only see a certain side of him. Maybe he's different elsewhere. Am I a truther or just a free thinker? I would say I'm just being skeptical. I'm not trying to take it to the conspiracy theory level. It just doesn't add up that you fly planes into towers and then they fall straight down. I mean, like, pretty freaking straight down. Somebody could show me the opposite argument. Like, so we have these conspiracy videos that show us, puffs of stuff coming from below where the building was falling that look kind of like demolition blasts. Okay, so what is that then? Somebody explain that. Is that like the interior structure fell 30 more stories before the top part? Or rather, was it a demolition that then cued the falling of this 30 stories above it? One makes more sense than the other, so somebody just dispute it. That's all I want. I just want to have a meritorious discussion on it. I don't want to have this hyperbolic back and forth of it has to be some... No, let's sit down, let's look at all the evidence, but we don't do that. We don't do that in this country for some reason. Anyway, dipping toes into crazy land. Yes, I do like to dip my toes into crazy land once in a while, but I try to have a moderate approach. Is uTorrent completely legal as long as you don't download copyrighted stuff? Yes, BitTorrent is completely legal as long as you don't download copyrighted stuff. In Australia, Dallas Buyers Club sued the government to hand over information of people who downloaded the movie, They won, but the major ISP said they didn't have the information. Both things are possible. It's weird that Dallas Buyers Club sued the government. In the United States, they're suing individual John Does through the court system. The ISPs could make a policy decision to only hold subscriber IP address information for a short period of time. And if there's no law telling them that they have to hold onto it for longer, then it's up to Dallas Buyers Club to get them the proper notices and court orders before that expires. And sometimes they don't catch the copyright infringement that quick and can't prepare the documents that quick. So it's a matter of the ISP trying to exploit loopholes in the law. Yeah, we're going to set up a system for Q&A at some point. This was more of a spur-of-the-moment thing that I saw a good story earlier, and I thought I'd do a live stream. What is Super Chat? Super Chat lets you donate money to me, and it appears at the top. It's a new, or the replacement for YouTube subscriber transaction donation, whatever. It's different from Patreon. This is just a one-time donation in chat. You're welcome to go ahead and try it. You just type 1000 into Super Chat and hit enter. Leonard, will you marry me? We can talk. The easiest way to put the torrenting is legal, piracy is not. Yes, that's correct, Nyan. Skeptic Sarah and I are going to have a disagreement about 9/11 later. What industry, in my opinion, has been the most sue-happy over pirating? It's the adult entertainment industry. There's one company called Malibu Media, another one called ME2 Productions. There was the Parental law thing. That was all pornography. Do I ever watch my own videos? Yes, I watch my videos very critically and try to identify where I should have done things differently and where I shouldn't be saying, and et cetera, and yada, 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 like I do over and over and over again. If a small business exists in a country and somebody tries to bring a franchise from another country with the same name, does the small business have rights to stop that franchise? Yes, sometimes if you can prove that your trademark existed before theirs, oftentimes your earlier trademark will have priority over the larger trademark. The larger trademark that's coming in, though, may still have some rights, and so you might have to have a geographical area or some limits or something on where your earlier but local mark would have rights over the later but larger mark. Have I ever thought of crossing into bird law? Absolutely. I just finished season 11 of Always Sunny. I have a shirt that you'll see on some of my live streams about Philadelphia bird law. And it's one of my favorite shows. The heat of the fire increased the internal air volume, which started pushing air out of the towers below. The heat from, in fact, it was severely insulated fire made them drop straight down. Okay, that's a perfectly fair theory, and I'm not saying that I'm a truther. Because I'm skeptical, but here, I just want to have this discussion. I want to understand from my own perspective how in the world a plane can fly into a building and the building falls straight down. That I do recognize the whole jet steel melt steel beams thing, and the flooring was like mounted in a way that made it easier to fall straight down and all that. That makes some sense, but still. But okay, I'm perfectly fine with that. I have a state program that is run as an agency, but is not counted as an agency. That's a weird one. Agency law is when the government establishes a group, an agency, a company, it's the government's company, to do one of the government's functions. And there are laws about how they have to advise and what kind of power they and what kind of authority they can give that agency. It has to be very, very tailored to the necessity of that agency accomplishing the functions of government. It's called administrative law. All lawyers have to take it in their law school, and it is very complicated. It's an entire career if you want to get into certain kinds of government service and things and understand how administrative agencies, promulgation of rules, rule making, all that comes into play. The best example that you may be familiar with is the Federal Communications Commission, and when they make rules about the net neutrality provisions in the United States, they have to propose the rules and accept comments for a period of time, and then make a final rulemaking and then promulgate that rule. It's all very complicated and uses some weird, unique terms, and everybody's got to understand how that works. If you're addicted to Listerine and your wife leaves you, can you sue them for ruining my marriage? Less likely Listerine, but let's say that there was a commercial for an alcohol product that went way further, went way over the top, said you're going to be able to have better sex and you're going to make more money and yada, yada, yada. And this wasn't just hyperbole, but they somehow convinced people that they really meant it, that this energy drink, for example, contains it's healthy for you, and so you can drink as much of this energy drink as you want, and you drank all this energy drink and it gave you a condition and all that, and your wife left you. Yeah, maybe you could sue for alienation of affections as well as some product liability or something like that. Yes, that is my tool bench behind me. I roll those things out and work on them when I work on stuff. What helped me survive 1L? Oh, I barely survived 1L. Let me tell you a very personal story, and then that'll probably be a good time to end the stream since we're about 2 hours in. So heads up, I'm probably going to end the stream soon. So Sarah, yeah, if you'd like to make your... I'm not a fan of Scalia, but... so how did I survive 1L? When I got to law school, I was an electrical engineer, or working as an electrical engineer trying to get some sort of recognition as an electrical engineer. And when I started law school, I had no understanding of legal proofs or legal logical thinking. I definitely very arrogantly considered myself to be a critical thinker, a skeptical thinker, and interested in the law, but I spoke in a very conclusory fashion, and I made lots of assumptions, and I could not articulate my legal arguments. And so I nearly failed out of school after the first semester. I had a very, very low GPA, and at my school, that low GPA was enough that I was put on probation, and if I did not get my GPA up to a much more significant number by the next semester, I would be out. And this caused me a lot of stress. I ended up needing to see a doctor for anxiety meds, and there were some problems with my girlfriend, and she broke up with me and everything because I had a huge anxiety problem. And so then the second semester, the law school had, believe it or not, a remedial law program. And they basically just started from square one. What's logical thinking? What are legal proofs? How do we write legal proofs? What's the basics of legal research so that when you get to your legal research class, you understand what's going on, etc., etc., etc. And it was extraordinarily clear and extraordinarily helpful. And my grades the next semester were much higher, and I indeed did eke out my required GPA, and was able to stay in school and finish school pretty much in the normal amount of time for a night school program, and passed the bar and everything without trouble. But yeah, barely survived. 1L. And so how I survived was with a lot of anxiety, on antidepressant and anti-anxiety meds, and by the skin of my teeth. So I wouldn't recommend doing it that way. I would recommend that you don't have relationship problems. I'd recommend that you are better prepared for making legal proofs and don't assume that you're just going to use your smart brain to know everything without trying. And I'd recommend that you ask your law school professors, and maybe there's some additional assistance from your law school to just help you help give you tips to get through it that are individual to you. I'm sure that they'll be able to help you. It's a lot of work at first, but once you get your brain oriented towards the type of logical thinking, it becomes much easier to work through. What I can tell you is, if you're a person like me who makes mountains out of molehills, it's easy to fall into a pattern of, oh, that's too hard, I'll learn that next time, and it'll just be good enough to learn this time. Sometimes you really do have to cite everything, and your paper really is going to take much longer than you thought, and that's just the way it is. Okay, so yes, 3 years if you go to school full time. Yes, it was another 2-hour stream. I was 27 when I got into law school, and I am 37 at the end of this month. Why doesn't my YouTube icon depict me with a hat? Oh my god, of course. Duh. I should have a freaking hat on. Oh man, you're right. You're absolutely right. Thank you for that. I'll have to change that. Yay, med school. Yes, was it 4 years of med school and then 3 years of residency? Thanks for the happy birthday wishes, Christina. 100 years of sex. I'm older than you barely. The camera softens my features. That's why I don't look 37. Okay, everyone, thank you so much for your contributions, for your chat messages, for your time and your attention, your interest in the law, and your subscription to my channel. I'm Leonard French, your favorite copyright attorney, and I think we might end with the same reggae song that we started with. So, mic muted, and